Okay, let's dive in. You've brought us some really interesting sources, legal texts, case law, notes, all focused on this idea of private nuisance. And I think for anyone listening, if you've ever wondered, is my neighbor's noisy habit or that weird smell actually crossing a legal line, then this deep dive is definitely for you.
Absolutely. That's the core question, isn't it? We're trying to unpack this area of law, figure out its main ideas, and see how it works as the rule book for neighborly disputes. It's fundamentally about balancing rights, your right to use your land and your neighbor's right not to be, well, unreasonably bothered by it.
So where's that line? When does something annoying become legally wrong?
Right. So first off, what is private nuisance? The sources define it as a civil wrong, a tort. It's about an unlawful interference that messes with a neighbor's use or enjoyment of their land.
And unlawful here isn't criminal, right? It means unreasonable.
Exactly. Unreasonable in the eyes of the law. It's this constant tension. I want to say, practice my drums. You want quiet. The law tries to find the balance. There's that old saying in the sources. No one should use their property in a way that injures their neighbor's property or comfort. That's kind of the guiding principle.
Okay. And typically, we're talking about things crossing the boundary
Right.
indirectly, like noise, smells, smoke, maybe vibrations, tree roots even.
Those are the classic examples, definitely. But here's the crucial part. It has to be substantial and unreasonable. The law doesn't really sweat the small stuff. We all have to put up with a bit of give and take, the odd barbecue, maybe some music on a Saturday afternoon. That's just life.
Right.
It only becomes a legal issue when the interference is serious, persistent, and unreasonable.
So it's like live and let live, but don't push it too far.
Pretty much. Think of it like rain, a few drops, fine. A flood ruining your living room, that's crossed a line. Or imagine a workshop next door. Some noise, you might expect it. But if they suddenly start blasting heavy machinery at 2 a.m., that's a different kettle of fish. It's unreasonable in that context.
Okay, got it. So unreasonable interference with land use. Now, who actually gets to sue if this happens?
Ah, yes, standing. This is key. Not just anyone bothered by it can sue. You need a legal interest in the affected land.
So like the owner, or maybe a tenant with a lease.
Exactly. Owners, leaseholders, people with what's called exclusive possession. But if you're just, say, a guest or family member living there but not on the lease,
Even if it's driving you crazy.
even then, legally, the nuisance isn't happening to you. It's happening to the person with the interest in the land. There's an old case, Malone v. Lasky, where a wife was injured by vibrations. She couldn't sue because only her husband, the tenant, had the legal interest.
Oh, okay.
And that was confirmed much later in Hunter v. Canary Wharf. Remember the TV signal interference case?
Vaguely, yes. Big tower blocking signals.
That's the one. The court again said you need that proprietary interest. Family members living there couldn't sue just because their reception was bad, though the court also found TV signal blocking wasn't a nuisance anyway, but the point about interest stood.
So the main takeaway is no property right, usually no private nuisance claim for you personally.
That's the general rule. Think of it like car insurance. If someone crashes into your car, you sue, or your insurance does. Not just any passenger who happened to be along for the ride.
Right, that makes sense.
Yeah.
Okay, let's flip it. Who can be sued? Who's responsible?
Good question. It's not always the landowner. Liability hinges on control or responsibility for the nuisance.
So who could that be?
Well, first, the creator, the person actually making the noise or causing the problem. Could be the owner, could be a tenant, could even be a contractor they hired, or someone not even on the land, like those examples of protesters causing disruption, or that oil tanker captain whose spill polluted the shore miles away. He created the nuisance affecting the land.
Because his actions directly cause the interference, even from afar.
Exactly. Causation is key. Then you have occupiers. That's usually the owner-occupier or the tenant in control of the property. They can be liable if they know about a nuisance on their land, even one started by someone else, like a previous owner or nature, and they don't take reasonable steps to stop it. They sort of adopt it by doing nothing.
Okay, so if my neighbor knows their overflowing gutter keeps flooding my path and does nothing, they could be liable.
Potentially, yes. They have a duty once they're aware of it.
What about landlords? If it's the tenant causing the ruckus?
Generally, the landlord is off the hook for tenant nuisances. But there's a big exception. If the landlord authorized the nuisance or knew it was practically inevitable when they rented the place out for a specific purpose, they can be liable.
Like that go-kart track example. The council leased the land knowing it would be noisy.
Precisely. They leased it for go-karting, which inherently involves noise, so they were held liable for authorizing the predictable nuisance. If the landlord knows the tenant's intended use is highly likely to cause a problem, they can't just wash their hands of it.
Okay, so they can't just turn a blind eye if they enabled the situation.
Right. And remember, liability can attach to anyone who creates the nuisance, regardless of whether they own or occupy the land where it starts.
It really comes back to who's responsible for the unreasonable interference. Like the driving analogy, the driver who crashes is liable. Maybe the owner too, if they let an unsafe driver use the car.
Very similar principle, control and responsibility.
Okay, we know who's involved. Let's get back to the core issue. What makes interference unlawful? That substantial and unreasonable test.
Yes. So, first hurdle. Is it substantial? The law ignores trivialities de minimis non cura lex, as lawyers say.
Meaning?
The law does not concern itself with trifles. It has to materially affect your comfort or your property.
So not just a whiff of smoke once, but a constant stink that makes you keep windows shut.
Exactly. Or noise you genuinely can't ignore. Something significant. Now, a crucial point here. If the interference causes actual physical damage to your property.
Like vibrations cracking walls, or fumes killing plants.
Yes. The courts basically say physical damage is automatically substantial and unreasonable. If your neighbor's actions physically damage your land or buildings, that's almost always going to be an actionable nuisance.
So the unreasonableness test is less complicated if there's actual damage.
Much less complicated on that point. The damage itself proves the unreasonableness, usually. It's the other type of interference, the amenity nuisance, affecting your enjoyment, where the reasonableness balancing act really comes into play.
Right, the noise, the smells, the dust.
This is where we ask, is the defendant's use of land acceptable, all things considered? Would a normal person find this level of interference tolerable in this specific place?
And you mentioned emanation earlier, something crossing the boundary.
Traditionally, yes. Noise waves, particles, water. Something had to travel from their land to yours. Blocking a view or TV signals by just being there wasn't usually enough.
But that recent case changed things slightly. Fearn v. Tate Gallery.
It did. It opened the door, suggesting that in really extreme cases, intense visual intrusion, like being constantly overlooked from a public viewing gallery right into your home, could potentially be a nuisance. It's evolving.
Interesting. So the law might be catching up with modern intrusions.
Possibly. But for now, the focus is still mostly on traditional emanations. And another key feature is that nuisance is usually about something continuous or ongoing, a state of affairs.
A persistent problem, not just a one-off incident.
Generally, yes. A factory that's always noisy, a drain that repeatedly overflows. Single events usually aren't nuisance unless they cause catastrophic damage, like that fireworks display fire case. It needs to be a pattern or a continuing issue.
Okay. You mentioned types of interference before. The sources group them. Can we revisit that?
Sure. It helps to think in categories. First, encroachment. Physical intrusion onto your land.
Tree branches, roots, maybe a fence built slightly over the line.
Exactly. Something physically crossing the boundary onto your property. You might have a right to carefully remove it yourself, abatement, but if it causes damage, it's likely a nuisance.
Second type, physical damage to your land or property.
We've covered this, but it's worth stressing. Activity on their land causes tangible harm to yours. Fumes killing plants, vibrations cracking walls. That St. Helens smelting case is the classic.
And this is the one where reasonableness is almost assumed if damage is proven.
Yes. Physical damage tips the scale heavily. It's considered inherently unreasonable.
Got it. And the third?
Interference with enjoyment or amenity nuisance. This covers everything else that affects your comfort and convenience without physical damage.
The noise, smells, dust, light. The things that just make life unpleasant on your property.
Precisely. Affecting your peace, making your home uncomfortable. This is where the reasonable user test, with all its factors, is most critical. That smelly pig farm case, Wheeler v. Saunders, fits here.
And the Fearn case, the overlooking one, falls under this too, as a kind of visual amenity interference.
Correct. An unusual example, but it fits that category of intangible interference with enjoyment.
So knowing the category matters mainly because physical damage is treated more strictly than amenity nuisance.
That's the key difference in approach. Physical damage, usually unreasonable. Amenity nuisance needs the full balancing test. The sources give those mnemonics, PEN or PIE.
Right, PEN. Physical damage, encroachment, noise amenity, or PIE. Physical intrusion, enjoyment helps frame the question.
Exactly. Is it invading? damaging, or just bothering your senses.
Makes sense. Okay, let's really dig into that reasonable user test for amenity nuisance.
Yeah.
How does a court actually decide what's unreasonable?
Right. This is the crux of it for noise, smells, and similar issues. It's a balancing act. The court looks at all the circumstances. It's not a simple formula, but a weighing of different factors.
Factor number one you mentioned was locality.
Yes, the character of the neighborhood. This is huge for amenity nuisance. What's reasonable depends on where you are.
The Belgrave Square versus Bermondsey idea.
Exactly. You expect more noise and bustle in a city center or an industrial area than in a sleepy village. The court asks, is this interference normal for this area, or is it completely out of place? A noisy garage might be fine in an industrial park, but a nuisance on a quiet residential street.
Okay, so context is key. What's next?
Duration, frequency, and timing. How long does it go on for? How often? And when does it happen?
Right. Nonstop noise is worse than occasional noise. And noise at 3 a.m. is definitely viewed differently than noise at 3 p.m.
Precisely. Continuous or frequently repeated interference is more likely to be unreasonable. Even seasonal things, if they happen reliably every year, can count. Persistence matters.
Okay. Factor three.
Intensity and extent. Basically, how bad is it? Is it a minor irritation or a major disruption? Noise so loud you can't sleep, smell so bad you feel sick. The greater the impact on an ordinary person's life, the more likely it is unreasonable. And again, physical damage is inherently intense enough.
Then there's the tricky one. Sensitivity of the claimant.
Yes. The law judges nuisance by the standard of the ordinary, reasonable person using their property in a normal way. If you are unusually sensitive or you're using your property for an unusually sensitive purpose,
Like my state-of-the-art recording studio needing total silence.
and the neighbor's activity wouldn't bother a typical resident, then you generally can't complain just because of your extra sensitivity. The neighbor isn't expected to cater to hypersensitivity.
But what if the noise would bother an ordinary person, even a bit?
Then it gets interesting. If the interference is already unreasonable for a normal person, the fact that it causes more harm to the sensitive claimant doesn't let the defendant off the hook. They can be liable for the full extent of the harm, even the extra bit caused by the sensitivity.
Okay, so the baseline is ordinary person. If it bothers them, the sensitive person can claim fully. If it only bothers the sensitive person, they likely can't.
That's a good summary.
What about motive and malice? Does why they're doing it matter?
Absolutely. If the defendant is acting purely out of spite, just to annoy the claimant, the court will almost certainly find it unreasonable. Malice poisons the well.
Like those cases of neighbors deliberately banging on walls during music lessons or shooting guns to scare animals.
Exactly. Using your property just to cause grief is not a reasonable use. Malice can make even borderline activities unlawful.
Okay. What about public benefit or utility? If the activity is useful.
This often causes confusion. The general rule is public benefit is not a defense to being found liable for nuisance.
So the noisy factory providing jobs can still be causing a legal nuisance.
Yes, and importantly, coming to the nuisance, moving next door to an existing operation, is also not a defense. The cricket club case, Miller v. Jackson, is a good example. Balls flying to the garden were a nuisance, despite the club's community value and the neighbors having built their house knowing the club was there.
But didn't you say public benefit can be considered?
Yes, but usually at the remedy stage. When deciding whether to grant an injunction in order to stop or just award damages money, the court might consider the public utility. They might say, okay, it's a nuisance, but shutting it down hurts the community, so we'll order damages instead. It influences the outcome, not the finding of liability itself.
Got it. And the last factor, foreseeability.
Right. The type of harm suffered by the claimant must have been reasonably foreseeable as a consequence of the defendant's actions. It's a sort of check against liability for completely unexpected results. But for most common nuisances, noise causing stress, smells causing discomfort, vibrations causing cracks, the harm is usually foreseeable.
Okay, so the court juggles locality, duration intensity, malice, sensitivity of the ordinary person, public benefit for remedy, and foreseeability. It's quite a complex mix.
It is. It really depends on the specific facts. There's no magic formula.
Let's try that hypothetical. Machine shop in a residential backyard, 8 a.m. to 6 p.m. weekdays. Loud noise, maybe some dust.
Okay. Locality. Residential. Big point against the shop owner. It's likely out of character. Duration timing. Daytime hours are better than night, but 8 to 6 constant is significant duration, probably leans against them. Intensity. How loud? If it disrupts normal home life for neighbors, that's bad for the shop owner. Sensitivity. If a neighbor works from home needing quiet, that extra sensitivity might not count unless the noise bothers everyone. Motive. Presumably running a business, not malice point for the shop owner. Public benefit. Earning a living has some utility, might influence remedy, but not liability.
So it sounds like the locality and likely intensity duration weigh heavily against them. Even if the timing and motives are okay, it would probably hinge on just how disruptive it actually is to the average neighbor.
Exactly. That's the balancing act in practice.
Now, even if the claimant proves nuisance based on these factors, can the defendant still get off? Are there defenses?
Yes, a few main ones. First, prescription.
The "we've been doing this for ages" argument?
Kind of. If the nuisance has been ongoing openly for 20 years without complaint or legal action, the defendant might gain a legal right to continue. But the clock only starts when it becomes a nuisance to the claimant. Remember Sturges v. Bridgman. The sweet factory noise wasn't a nuisance until the doctor built his consulting room next door. The 20 years hadn't run since then. It's tough to establish.
Okay, next defense. Statutory authority.
This is a strong one. If an act of parliament specifically authorizes the activity, and the nuisance is an inevitable result of doing what the statute requires or permits, that's a complete defense.
Like operating a railway or airport under specific laws.
Exactly. Or that oil refinery case, Allen v. Gulf Oil. If Parliament says do this, and doing it unavoidably causes nuisance, the statute provides immunity.
That's very different from planning permission, right?
Absolutely critical difference. Getting planning permission from the council does not give you a license to cause a nuisance. It's not a defense.
But it's not irrelevant either.
Correct. Planning permission can be evidence that helps change the assessment of the locality factor. If a whole area is rezoned for industrial use, what's considered reasonable noise there might change. But the permission itself doesn't excuse the nuisance. Coventry v. Lawrence clarified this. It's evidence about the area's character, not a shield.
Okay. What about act of God or stranger?
This covers things truly outside the defendant's control, freak weather events, or actions by trespassers they couldn't reasonably prevent. But if a nuisance arises naturally, like a landslide, or is caused by a stranger, the occupier can become liable if they know about it and fail to take reasonable steps to deal with it.
So passive acceptance isn't always okay.
Not if you know about it and can reasonably act.
And just to hammer it home, coming to the nuisance is not a defense.
Absolutely not. Buying a house next to an existing nuisance doesn't stop you from suing if that nuisance is unreasonable. The focus remains on the defendant's unreasonable use of their land.
Right. So if nuisance is proven, no defenses apply, what happens? What are the remedies?
Primarily an injunction. A court order to stop or limit the nuisance. It might specify hours of operation, noise levels, require filters, etc.
Tailored to fix the problem, hopefully.
That's the aim. Second, damages. Money to compensate the claimant for past harm, reduced property value, loss of enjoyment, maybe repair costs. Sometimes damages are awarded instead of an injunction, especially if stopping the activity has major public consequences.
Like the cricket club example. Pay for the broken windows, but keep playing.
Essentially. And finally, abatement. The self-help remedy. Carefully cutting back those overhanging branches, for example. But you have to be reasonable and usually give notice.
So courts have tools to try and find a fair outcome.
Yes, aiming for that balance where possible.
Okay, let's try a quick wrap-up of this whole complex area.
Sure. Private nuisance. Protects your land's enjoyment from substantial, unreasonable interference.
Who can sue? Need a legal interest standing.
Who gets sued? The creator or the occupier who adopts or continues it, or sometimes a landlord who authorized it.
Types of interference. Pen and pie, physical damage, almost always unreasonable, encroachment, or noise amenity enjoyment issues.
For amenity nuisance, is it unreasonable? Apply the balancing test. Locality, duration intensity, malice, sensitivity, ordinary person standard, foreseeability. Remember, public benefit mainly affects the remedy.
Defenses. Prescription, 20 years, statutory authority, Parliament's permission. But not planning permission, just evidence of locality and not coming to the nuisance.
Remedies, usually an injunction, stop limited, or damage is money, sometimes both, maybe self-help abatement.
Thinking about those concrete examples, the noise, the smell, the roots, the dust, really helps tie the rules together.
It does. At the end of the day, it's about navigating that often difficult line between neighbors.
It really highlights how tricky it is to live side by side.
Yeah.
The law steps in when that live and let live idea breaks down too badly.
Exactly. And it's always evolving. That Fearn case about overlooking shows that what we consider an unreasonable interference can change as society and technology change. It leaves you with a big question, doesn't it?
Which is?
In our modern, often crowded world, with people using property in ever more diverse ways, how do we find that reasonable balance with our neighbors? How do we coexist without constantly needing lawyers and courts to draw the lines for us? It's a fundamental challenge.
A very relevant thought to finish on. Thanks for breaking down private nuisance for us.